Parliament has recently, or the National Assembly has recently adopted the Expropriation Bill. That's a piece of legislation that's been in the works since 2008, and that's been, we've seen strong opposition from critics who say it will undermine property rights and investor confidence. Joining us in studio to discuss this legislation and what the implications will be for South Africans and foreigners, we've got Ben Winks. He's the associate at Herbert, Freehills, South Africa, and Pierre Venter. He's the general management for human settlement at the Banking Association of South Africa. Gentlemen, thank you so much for joining us this afternoon. Ben, let me start with you. Expropriation Bill in South Africa, what is it and why do we even need it?
Well, expropriation is a process where the state takes ownership of property that is previously privately owned. So, for example, if there's some compelling public need or public interest for a pipeline, a power station, a road, or perhaps for something like land restitution, then the state can, by notice and engagement with the private landowner, take ownership of that land and then use it for that public purpose. Now, it's a very contested process because, of course, people don't necessarily want to part with their property, and if they will part with their property, they will do it only in a process that is fair and against compensation that is just and equitable. And generally, people would want to be compensated not only for the market value of their property, but also for the inconvenience of having it taken away from them without their consent, really.
Pierre, we always think of the expropriation bill or land expropriation, and we think it's just something that will affect farmers. But it's not just farmers who will be impacted. And how does this process work if your piece of property, your land, has been earmarked for this?
Okay, I think firstly to say to you that if you look at the definition of property, one needs to do so in the widest context. So you need to look at property and say it includes movable and immovable property, it includes tangible and intangible property, it includes corporeal and incorporeal rights, and that includes intellectual property and patents and so on as well. So one needs to look at it in the broadest sense. It's not just about land.
So if your property is being earmarked, what do you do?
Well, well, in the first instance, a lot of people, well, let's just take it back a step. And Ben made the point that this is the compulsory acquisition of your property against your will. This is what an expropriation is. Yes. But before that stage, if the state wishes to acquire your property, it will engage with you with a view to actually buying your property. And a lot of matters are resolved on that basis where it never ever goes to expropriation. Expropriation is really a last resort where a property owner is not prepared to part with their property without the state enacting its judicial rights to actually force the transfer of that property out of their name. So very few properties have historically gone to expropriation, and one would hope going forward that we would continue to see the same thing, that if there is a wish by the state to actually acquire my property, I would receive a fair price for my property, and I would be prepared to part with that property on an amicable basis without having to go through this process.
Ben, there have been a lot of criticisms around expropriation, and you mentioned in your last answer was that this maybe could go towards land redistribution, land reform, and the use of this particular piece of legislation. Would this not be the right legislation to ensure that we've got land reform that is done in an equitable way or in a proper way, so to speak?
Yeah, well, legislation like this is crucial for any land reform process to be undertaken in a procedurally fair, uniform, and the least disruptive manner possible. The contested question, the reason why this bill is so controversial is really it's about compensation. Yes. So on the one extreme you have groups like the Economic Freedom Fighters in Parliament who opposed this bill because they said, well, there shouldn't be provision for compensation at all. There should be no compensation for expropriation, and that's been a policy position of theirs for a long time. On the other extreme you have free market type of interest groups and the Democratic Alliance saying that compensation must be fixed at market value. Now, what the Constitution says is that it's not as simple as that compensation for expropriation must be just and equitable, taking into account all relevant circumstances. So neither of those two fixed extremes is really compatible with the Constitution, because the circumstances might call for compensation that is much less than market value. If, for example, it would unjustly enrich the previous owner for them to be given market value for a variety of reasons. And it might be unfair for someone who owns land that doesn't have a particularly high value. And maybe this is someone who is not only currently poor, but they received that land in a land restitution process. It's not fair for them to be given no compensation. Yes. So both of those extreme positions is really not conducive to a meaningful land reform process. You do need to treat each case on its merits, and it's precisely for that reason that you need this kind of uniform and fair framework for people to make representations, lodge objections, be heard, and for the government to take those objections into account.
Pierre, let's get you weighing in this conversation. As Ben was talking, you were nodding your head there in agreement. So there definitely are some challenges that we are seeing with this expropriation legislation.
Absolutely. Look, I think firstly, let me say to you that I think it's an improvement on the 1975 current act around expropriation. It is aligned to our Constitution, and if more specifically Section 25 of our Bill of Rights within our Constitution, which talks about property. So I think that was there was a need to actually replace the old piece of legislation with this one. I think the real concern is whether just and equitable compensation will be paid to property owners upon expropriation. With the introduction of with the alignment to our Constitution, those 5 factors, which is market value, the history of acquisition, current use, the purpose of the expropriation, and any investment that the state made into your property, those other 4 factors may well be taken off market value. So you're going to find a lot of owners believing that they have been they've been deprived of their rights with inadequate or no compensation being paid for their property. Now, where this leads to is it creates investor concerns.
Yes.
You need investor confidence for people to actually invest in our economy, and that's both international investors as well as local investors. There's another concern that I want to table as well, and that is the concern that lenders have, because we, in terms of the Banks Act, which in turn is formulated from global regulation, we have to value property at market value. And if the amount of compensation paid is below market value, banks will lose money, and it's an unquantifiable risk for us. So if you look at the uncertainty that this policy framework creates,
yes,
what we will see over the next 5 or 6 years is certainty being brought in as matters are contested in the Constitutional Court, because remember, this is aligned to the Constitution. So our Constitutional Court, you will find these matters escalating all the way through to that level. Now, that costs a lot of money, and it's fairly time consuming. So for some years, we're going to sit with policy uncertainty around this particular bill soon to be enacted.
I have to wrap up the conversation. Ben, let me just get a closing remark from you. We're sitting with some uncertainty, as Pierre has said. What is the next step forward regarding this?
Well, the bill will now go to the National Council of Provinces, which is the other House of Parliament, and the public will be invited to make submissions. There are still some areas of concern in the bill. It has been improved dramatically since the first version, and it's a tremendous improvement on the current act. One critical thing that has been achieved is that now, if the state doesn't like the amount that a person is asking for, the state has to take the matter to court to get a decision on what is just an equitable compensation, and not the other way around. And that was through a process of engagement and public submissions that improvement was achieved. So only through more engagement, more public scrutiny can the bill really come to something that will enhance rather than diminish investor confidence.
Now, more and more engagement we need until we get some clarity on this. As Pierre said, this is creating some uncertainty, and Ben has reiterated that we will continue to see engagement, and this is an improvement from the previous one. A very big thank you to my guest this afternoon, Ben Winks. He's the associate at Herbert Smith, the Freehills, South Africa. Pierre Venter, General Management from Human Settlements at the Banking Association of South Africa.